Very good afternoon to all. Thank you, Chair and Co-Chair. So I have been given a topic, a critique on the legal and regulatory framework for nuclear renaissance. So I just thought that in the last 3 days we have been listening about the framework, regulatory framework, etc. I'll dwell a little bit a different topic on the legal aspects of it. So coming to the word framework, basically as defined in the Cambridge Dictionary, framework is a supporting structure around which something can be built. So basically it is the skeleton on which the entire system rests. So it can be understood as a system of rules, ideas, or beliefs that is used to plan or decide something. So my idea today is to analyze those beliefs, those ideas on which the entire legal framework evolved. For this, since we are looking for the nuclear renaissance, which is for the future, the answer lies in the past. We should go back and look in the past. With this intent, I go back right before the pre-independence day, when we didn't even have our Constitution of India. The governing act was the Government of India Act 1935, which basically gave the framework for Constitution of India later on. And it had 3 lists as we have in Constitution. That time it was known as the Federal List, Provincial List, and the Concurrent List. And the Federal List had 59 items. But there was no item on atomic energy in that list. But still, there were 2 entries in the Federal List, which said, development of industries where development under federal control is declared by federal law to be expedient in the public interest, lies with the central government. Second, regulation of mines and oil fields and mineral development to the extent to which each regulation and development under federal control is declared by federal law to be expedient in the public interest. These were the 2 governing entries in the Government of India Act, which permitted the government later on to have what is the Atomic Energy Bill 1948 to be enacted that time. In fact, pre-independence in January 1947 in the Indian Science Congress, Pandit Jawaharlal Nehru had highlighted the importance of atomic energy. And if you read the statements and objects of the Atomic Energy Bill 1948, it says that atomic science is one of the newest science and it has given to the mankind various tools to fight diseases, elevate sufferings, etc. and also as a concentrated source of power. It highlighted that development and use of atomic energy is a question of national importance. The Atomic Energy Bill would give the government powers to control the development of atomic energy in India and the disposal of the relevant raw materials so that this may be used for the advantage of the people as a whole. In order to ensure secrecy, provisions have been made in the bill for security measures which would be necessary. This was the basic object of Atomic Energy Bill 1948, and there was a very prominent section, Section 2, because this act was being framed under the Government of India Act, which has to say that the federal law intent for the public interest. It says that declaration as to expediency of central government's control. It is hereby declared that it is expedient in the public interest that the central government should take under its control the development of any industry connected with production or use of atomic energy, any mineral which is or may be used for the production or use of atomic energy, on research into matters connected therewith. And the governing section under the Act was Section 10 of the Atomic Energy Act 1948, which provided for this control. Basically, it was a negative right. Everything was prohibited except under a license. So whatever was written there, like any prescribed substance or any mineral which can be obtained or any plant design, any activity was prohibited per se unless permitted by a license. And thereafter, when the Act came into picture in 1948, the very first in June 1948, Department of Scientific Research was created. Atomic Energy Commission was set up in 1948 under that Department of Scientific Research, and very first of the attempts was to have self-reliance in this field to acquire the raw materials, for which in July 1949 the Rare Earth Survey Unit, which was later, as we know today, is AERB, was set up. And two important control orders were issued. The very first was the Atomic Energy Control of Production and Use Order 1953, which was the governing legislation to control any activity under the Atomic Energy Act. Thereafter, in 1950, the Constitution of India came. So what was the fate of the earlier laws, the Atomic Energy Act, which was passed in 1948? The Constitution of India, Article 13, specifies pre-constitutional laws insofar as they are inconsistent with the provisions of the fundamental rights guaranteed to the Constitution shall, to the extent to such inconsistencies, will be void. But Atomic Energy Act, which derived its entire premise from the 7th schedule of the entry, that is Parliament to legislate on matters related to atomic energy and minerals resources necessary for its production. This was the first time the atomic energy was built in the Constitution of India, and the Atomic Energy Act 1948 remained in force. Thereafter, lots of development took place. 1951, the uranium deposit at Jadugoda was discovered. 1952, IRL was set up at Alway. 1954, DAE came into picture. 1957, our BARC, that time the erstwhile Atomic Energy Establishment, Trombay, was set up. 1959, uranium metal plant in the Trombay produced the first ingot of uranium. So a lot of things were happening. And 1956, Apsara got critical. 1960, Cyrus got critical. With all these developments in place, the Atomic Energy Act 1948 was not thought to be enough, or not thought to be having sufficient provisions to give powers to the central government to control the future activities. With this, the bill was again introduced in 1962, and then Prime Minister Jawaharlal Nehru, in his remarks while introducing the bill, said that it might have been possible to make amendments to it, but that was a cumbersome procedure with numerous petty amendments. It is therefore submitted to the House that we should put up an end to the old act and introduce a new bill, which I am venturing to do now. So that way, the Atomic Energy Bill 1962 was introduced. The major features with 1962 bill brought in was atomic energy minerals, anything relating to them should be under the ownership of the government, and there was a special provisions for safety. For very effective safety measures have to be taken in dealing with the production of atomic energy anywhere, and few other provisions related to patents and penalties were made. These were the major changes in the 1962. With this, the Act came into force on 21st September 1962, and it had three parts. The main preamble of the Atomic Energy Act states, development, control and use of atomic energy for the welfare of the people of India for other peaceful purposes. Now this is a very loaded and a very important preamble of the Act, which was debated in detail by Honorable Supreme Court in the Kudamkulam judgment. And what they interpreted is the concept of welfare state is a facet of Article 38 of Constitution of India. It is the obligation passed by the Constitution of the state to establish a welfare state. The words used in the preamble of this Act are welfare for the people and peace. So they quoted two Latin maxims. One, the maxim salus populi suprema lex, which means the public welfare is the highest law. The second, salix republicae suprema lex, which means the state is the supreme law. Basically what is meant is that the safety of the people and the safety of the nation, both are the facets of the welfare state, and these both are included in our Atomic Energy Act. So the term welfare covers both public safety and the welfare of the citizens, and considers both living generations in presently and generation to come in future. This was how they have interpreted the entire welfare definitions in the Atomic Energy Act. So basically what does the Act say? It says control over production, development and disposal of atomic energy. That is the first block. But what is required for the atomic energy? We require prescribed or radioactive substance or articles. So control over manufacture, either otherwise produce or buy or otherwise acquire, store or transport this prescribed substance and radioactive substance for the production, development and use of atomic energy, and in the process dispose of such prescribed substance and radioactive substances produced and any matters connected to research therewith. So this entire thing is the control element of the Atomic Energy Act, which lies with the central government. So why control? There are 4 elements of control given in the Atomic Energy Act. First is the control is required for maintaining security, for ensuring secrecy. The control is required for safety, is required for inventions, and is required for electricity supply. And which entity was permitted under the Atomic Energy Act? In 1962, it was either by central government itself or through any authority or corporation established by it. And who is the central government wing of the thing? It was again clarified by, not clarified, it was the allocation of business rules which actually defines the transaction of business in the government, in which Department of Atomic Energy was made responsible for all matters related to administration of Atomic Energy Act 1962. So this is a slide which in a nutshell gives the entire legal licensing framework under the Atomic Energy Act. It says that Section 14 and Section 16 are the 2 important sections of the Act which provides for control of atomic energy and control over radioactive substance, whereas for which any mines or mineral development or any plants established will, or any equipment used will be under the control. If you see in this diagram that I have kept the rightmost side, use of radiation generating equipment away from the control element. That's because radiation generating plant, although coming under the purview of safety under that Section 17, does not come under the purview of control under the Atomic Energy Act, which yesterday Dr. Pankaj Tandon has told in detail that LINACS, etc., there are line ministries and other ministries which are exercising the control. The safety anyway will be under the Atomic Energy Act. So we have Section 14 and 16 under specifying the control for atomic energy and radioactive substance, for working of mines and minerals, for acquisition, production, use, etc., of prescribed substance or prescribed equipment, and on the other side the safety for again the same thing. Well, the only difference is under the control we have the control is to be exercised to a license by rules under Section 14, and for the safety the provisions are again through rules. So which are these rules? As in the earlier lecture we had seen, Dr. Solanki has projected the various rules framed under the Atomic Energy Act, deriving their enabling sections under which they are formed are depicted here. The governing rules which AERB is now looking after are the radiation protection rules, the safe disposal rules and the factories rules. And on the left hand side, the 2 most important rules which are under which the licensing framework is being administered by the Department of Atomic Energy is the Atomic Energy Working of Mine Minerals Rules and the Control of Food Irradiation Rules, again on which there was a lecture yesterday by Mr. Petupal. So all this was good, but in 1987 there was a need to again amend the Act. And this is while introducing the amendment, then Honorable Minister of State Shri K.R. Narayanan told that it is till now the Atomic Energy Act provides only the central government has the power to produce and supply electricity from atomic energy. But now we want to expand it to other bodies. Hence, there was some requirements for amending Section 3 of the Act for production and development and use of atomic energy and disposal of the connected material. And some consequential elements in Section 22, which relates for supply of the electricity, fixing of tariffs. In fact, Section 22(1) it said, the Act is being amended to allow such a body so as to fix tariffs on the rates similar to that adopted for generating companies like NTPC. And Section 23 was again amended so that the Administration of Factories Act can be made applicable to such other bodies. With this, the reason for the amendment was the proposed amendments are purely for enabling nature, made with the intention of creating a wholly owned government company for the purposes of speedy execution of the goal of 10,000 megawatt by 2000 AD, It is proposed to call the corporation the Nuclear Power Corporation of India Limited. It will be our endeavor to ensure that the new corporation function as a self-sufficient, viable organization. And as debated, because the only basis by which we can come to know today the basic ideas are the legislative debates. And the Rajya Sabha and Lok Sabha debates have now categorically mentioned that the bill enables central government to establish an independent authority under the overall umbrella of Atomic Energy Commission and the Indian government to look after the generation of nuclear power, its distribution, to coordinate such with the state governments about the supply and fixing rates, etc. So Atomic Energy Act Amendment 1987 got passed in 1987 with the definition of government company stating, which means a company which has more than 51% paid up share capital held by the central government. And to that extent, there were other amendments in section 3, 22 and 23. So that was the legal framework progressing. On the other side, in parallel, the Tarapur 1 and 2 was getting commissioned, and Dr. Iyer is here. We have a WhatsApp group as tribute to Dr. A.S. Ganguly, who was the head HPD then, and he was called in to chair a safety committee of Tarapur 1 and 2, which later on became the DSRC. In 1971, when the RAPS 1 was coming up, and this DSRC later on became the regulatory framework on which today AERB stands. So basically in 1983 when AERB got constituted, DSRC and DRP both were supposed to assist AERB, which subsequently got subsumed in AERB in 1987 with the recommendation of second Mechanical Committee report, and as such the regulatory framework developed. So basically today the existing governmental framework is, there's a control of nuclear facilities by Department of Atomic Energy, there's a safety framework by AERB, there's an environmental protection framework by Ministry of Environment and Forest, there's a disaster management framework by NDMA, which yesterday Mr. S.K. Ghosh has presented. So the legal framework has, as I defined, has the hierarchy of Constitution, the Parent Act, the implementing rules, and the notifications. And then there's a regulatory framework for control and regulatory framework for safety. As far as the safety is concerned, we have seen in the last lecture how the codes, standards, manual guides, etc. have been evolved. The other part, the regulatory framework for control, today is, because it lies with the government, it's been exercised by the department, and there is no defined framework existing, it is implicit. So basically what is being the practice today is the control, the site selection, and the in-principle approval for the site by the government as a pre-project activities, project approval by the Atomic Energy Commission based on the DPR, financial and administrative sanction by Atomic Energy Commission, and thereafter at the time of handling of prescribed substance, the license for handling by Department of Atomic Energy. And the elements seen considered while the exercising control are resources and infrastructure, which are again implicit, the security arrangements and the safeguards arrangements. As far as safety is concerned, stage-wise licensing and continuous regulatory oversight, the selected site fulfills the safety requirements, the permitted activity is carried out in a safe manner throughout the facility's lifetime, including all other associated activities, training, qualifications are coming under the gambit of safety. The elements seen here, that the regulations which are based on scientific principles, concurrent development of regulations with technology, the regulatory approach developed based on licenses maturity. These were the governing factors on development of the safety regulations. 2015, again, the bill was proposed to be amended. Here, the purpose of the present amendment was to propose an enabling legal basis for Nuclear Power Corporation of India Limited to form joint venture with other government units and PSUs for nuclear power protection. The need for this was arisen to meet the immediate requirement of equity infusion to augment country's nuclear power generation capacity. So basically there was two proposals in this amendment. One being joint ventures with PSU and other government units under the definition of the government company. And the second is to extend the control of central government over such joint ventures in which otherwise the central government is not a direct shareholder. With this understanding, the government company definition was amended, wherein government company would mean not less than 51% of the paid up share capital to be held by central government, same that was earlier, or the whole of the paid up share capital is held by one or more of the companies specified under the same clause, and which by the article of association empowers the central government to exercise its control over the board of directors. So basically what it says that two government companies can come together, have 51% whole paid up capital and form a joint company, provided their board of directors are governed by the central government, which in this case is Department of Atomic Energy. So with this, the section 14 also was amended that license can now be given only to a government company, and when the government company ceases to remain a government company, entire assets will come back to the government. So Atomic Energy Act 2015 got amended, and then this was challenged very recently in the Supreme Court, saying that this amendment was arbitrary, because it does not allow private party to come in the act in the nuclear power production, so it is arbitrary in nature. The Supreme Court, while deciding this matter, has recently, it was in 2024 itself, it said that the very purpose of this amendment is to serve a salutary public purpose. The parliamentary regime envisages a calibrated exploitation of atomic power, subject to stringent safeguards, bearing in mind the likely consequence of misuse and of that matter accident. And to this backdrop, even in the Civil Liability Nuclear Damage Act parliamentary debates, then Prithviraj Chauhan, the Honorable Minister of State, had categorically told that we will not permit any private sector, whether Indian or foreign, to come and operate nuclear power energy. That was the statement given to the parliament at that point of time. But now the things are emerging, and we are all hearing news of various diverse entrants in the nuclear power for the nuclear renaissance. So there are various operator and owner organizational structures, and IAEA's nuclear energy series has given some of these examples. It can be by turnkey approach, where the operator is only taking a managerial control, not the complete exercise control of the design, fabrication, etc. There is a split package approach. There is a build, own, operate approach, which is a variant of, again, another variant is build, own, operate, and transport approach. And there is even another approach where the owner and the operating organization can be separate entity, and the relationship will be defined by a contract. So all these different permutation combinations are possible, for which when the new entrants in nuclear sector come in, definitely it will necessitate changes in the Atomic Energy Act itself. It will necessitate changes in civil liability regime. There are major policy considerations to be taken into account. For example, today the way the fresh fuel is acquired by the government and then given on lease, and the spent fuel and they require the today India requires that any imported fuel, the complete reprocessing rights is reserved by the government of India under IA safeguards. But then in future there may be a clause of having a repartition back of the spent fuel, which may be a point of contention. The complete fuel cycle support to these industries, the waste management arrangements, decommissioning arrangements, the technical services which are today provided by BARC, the personal monitoring services provided by BRC, the Administration of Factories Act today, which is there in the government company, how it will be administered in all over when the new entrants come in. So these are various policy considerations by the government. And basically towards this, the regulatory framework for the control part, explicit provisions for evaluation of the organizational capabilities, technical and commercial competencies, resources, infrastructure, liability arrangements, interfaces, security and safeguards, EPR arrangements, intelligent customer capabilities, and the rejection criteria in case a company does not fail. All these are the elements of control which has to be explicitly written down. Towards this, AERB had done its manthan, and the Government of India department to take into these aspects for consideration. Coming to our own house, that is in AERB, there are a series of manthan we have already discussed seen in the earlier lectures, so I will not dwell in those parts. There are how the regulations has to be relooked for non-prescriptive technology and entity-neutral regulations, that to the extent practicable, requirements which are compatible to any business model, assessment of utilities management system, organizational setup with contractual arrangements, corporate safety and security policies, safety culture assessments. These are all the things which are all being discussed in AERB, debated in AERB, for which Manthan series are taken place, implied to express regulatory requirements. The way the CLND Act says, latent and patent error, here what I say is we should now codify the latent and patent experiences of handling with NPCL in our regulations. And finally, the optimization of the regulatory processes, the review timeline, the functioning decision making, all these are being discussed in AERB. To sum up, so far the legal and regulatory framework was developed right from the inception, centered around government's exclusive control over nuclear energy sector. The amendments which have taken place over the time, especially 1987 and 2015, also retain this basic premise. For enabling new entrants, changes would be required in the basic framework on which the conceptual ideas were built and evolved over the years. The changes need to be seen from a holistic, broader and deeper perspective, seamlessly integrating the body and soul of the legal and regulatory framework. Thank you, sir.